Madam President, members of the Court, it's a privilege to appear before you and an honour to do so on behalf of the Republic of South Africa. This case is brought under Article 9 of the Genocide Convention, which entitles any contracting party to the Convention to submit to the Court disputes relating to the interpretation, application or fulfilment of the Convention. The Court does not at this stage have to determine whether or not Israel has or has not acted contrary to its obligations under the Genocide Convention. That can only be done at the merits stage. It's concerned now only with the question of what provisional measures are required pending the Court's final decision on the merits. The Court's jurisprudence points to 5 requirements for the ordering of provisional measures. The first is that there should be prima facie jurisdiction, and that was addressed by Professor Dikgang. The second is that there should be a link between the measures requested and the rights underlying the main claim. This requirement is plainly satisfied. The measures request an order that Israel does not violate the very rights secured by the Genocide Convention as set out in South Africa's application. The third is the plausibility of the rights that are claimed. Professor du Plessis explained that this is clearly satisfied. The rights claimed are the very core of the Convention, notably the right not to be killed or seriously harmed, and the right of the group not to be physically destroyed. Fourth and fifth, there must be a risk of irreparable prejudice capable of arising prior to the final determination of the dispute, and there must be urgency. Ms. Negroli addressed those points. Israel has, for over 3 months, been mounting a continuous siege and bombardment of Gaza of a ferocity and duration that can only be seen as an attempt to destroy Gaza and its citizens. And it is publicly asserting that it will continue to do so. You are aware of the scale of the death and the scale of the destruction, and it is continuing at this very minute. The Court has said that, quote, a state's obligation to prevent genocide and the corresponding duty to act arise at the instant that the state learns of, or should normally have learned of, the existence of a serious risk that genocide will be committed. From that moment onwards, if a state has available to it means likely to have a deterrent effect on those suspected of preparing genocide or reasonably suspected of harbouring specific intent, it is under a duty to make such use of those means as the circumstances permit. End quote. And that is what South Africa has done by making this application. In cases such as Lagrande, Avena, Jadav, this Court has exercised its power to order provisional measures, having regard to the impact not only of provisional measures on the state's parties to a case, but also to the impact on the individuals directly affected and their rights. It has issued orders to restrain states from killing individuals in a manner alleged to violate international law. And that is what South Africa is requesting, after more than 23,000 individuals have already been killed in the siege and bombardment of Gaza, the overwhelming majority of them innocent men, women and children. The Court also issues orders to safeguard the integrity of its proceedings. and the efficacy of its final ruling. In the Bosnia genocide case, for example, you ordered that the parties, quote, not take any action and ensure that no action is taken which may aggravate or extend the existing dispute over the prevention or punishment of the crime of genocide, or render it more difficult of solution, end quote. Without such non-aggravation orders, there is a real risk that a respondent will rush to comply, otherwise must stay within the limits set by international law, including the explicit duty in Article 1 of the Convention to prevent genocide. South Africa believes that the publicly available evidence of the scale of the destruction resulting from the bombardment of Gaza and the deliberate restriction of food, water, medicines and electricity available to the population of Gaza demonstrates that the government of Israel, not Jewish people or Israeli citizens, the government of Israel and its military is intent on destroying the Palestinians in Gaza as a group and is doing nothing to prevent or punish the actions of others who support that aim. And I repeat, the point is not simply that Israel is acting disproportionately. The point is that the prohibition on genocide is an absolute, a peremptory rule of law. Nothing can ever justify genocide. No matter what some individuals within the group of Palestinians in Gaza may have done, and no matter how great the threat to Israeli citizens might be, genocidal attacks on the whole of Gaza and the whole of its population with the intent of destroying them cannot be justified. And no exception can be made in a provisional measures order to allow a state to engage in actions that are capable of violating its obligations under the Genocide Convention. It is unthinkable that a court would ever do such a thing. That is the simple point in this case. Genocide can never be justified in any circumstances. Israel's actions will be examined closely and methodically at the merit stage, when the court will want to hear what Israel has to say in its defence. What matters now is that the evidence indicates that Israel's actions have violated its obligations under the Genocide Convention, that they continue to violate them, and that Israel has asserted that it intends to continue them. Israel may say that it will comply with all of its obligations under the Genocide Convention and that orders from the court are not necessary. But in previous cases, the court has held that such unilateral statements do not remove the risk of irreparable prejudice or obviate the need for a court order. In this case, one reason for doubting the efficacy of any such unilateral undertaking is Israel's apparent inability to see that it has done anything wrong in grinding Gaza and its people into the dust. Another reason is that a departure from or reinterpretation of any unilateral undertaking by Israel may lead to consequences so appalling that the risk simply cannot be taken. But there is a third reason. As was noted during the submissions to this court in the case concerning the reservations to the Genocide Convention in 1951, quote, "The obligation to submit disputes concerning the interpretation or execution of the Convention to the International Court of Justice was regarded as one of the prime guarantees of the due fulfilment of the basic obligation to prevent and punish the crime of genocide," end quote. The role of the court which unusually extends not only to the interpretation and application of the Convention, but also to its fulfilment, is pivotal. In addition to their substantive obligations under the Convention, it is vitally important that states respect the court and their procedural obligations. This is not a moment for the court to sit back and be silent. It's necessary that it assert its authority and itself order compliance with the obligations under the Genocide Convention. Indeed, it's hard to think of a case in recent history which has been so important for the future of international law and of this court. Madam President, members of the court, that concludes my submission. I thank you for your attention, and unless I can help you further, I would ask that you call on South Africa's agent to read out the request for relief.